the first one is the most important. Not making the deal clear with your co-founders, and I can't stress enough on the importance of this. So this is from the movie Social Network for those of you who guessed. But this is just one example or one story in my kind of repertoire of stories that I have on co-founder disputes. Uh, in my experience, one of the most common reasons for startups failing that I've seen are because of co-founder disputes. Uh,
Mark!
He's wired in. Sorry? He's wired in. Is
he?
Yes.
You issued 24 million new shares of stock.
You were told that if new investors came
along... How much
were
your shares diluted? How much were his?
What was Mr. Zuckerberg's ownership share diluted down to?
It wasn't.
What was Mr. Moskowitz's ownership share diluted down to?
It wasn't.
What was Sean Parker's ownership share diluted down to?
It wasn't.
What was Peter Thiel's ownership share diluted down to?
It wasn't.
And what was your ownership share diluted down to?
0.03%.
You signed the papers.
You set me up.
You're gonna blame me because you were the business head of the company and you made a bad business deal with your own company?
It's gonna be like I'm not a part of Facebook.
It won't be like you're not a part of Facebook. You're not a part of Facebook.
My name's on the masthead.
You might want to check again.
It's because I froze the account? I'm not signing those papers.
We will get the signature.
And I'll bet what you hated the most is that they identified me as a co-founder of Facebook, which I am. You better lawyer up, asshole, because I'm not coming back for 30%. I'm coming back for everything.
Okay, so just one example of a situation where either you don't have an agreement or you have an agreement which has not been properly structured or negotiated, keeping in mind the interests of all the parties, right? I'll talk about another example that I often talk about. A client of mine actually, who was running a very, very interesting and then successful company in Bombay, two co-founders, both having an equal shareholding in the company. One of the founders, 6 months through, decided to take a short vacation to Europe. And kid you not, it's been 2 years and he's not come back. But what's interesting is the guy's still sitting on 50% equity, right? And the company's shut down now. But what's important to note is that when you start a company with a co-founder, friends, family, or otherwise, often happens. I mean, the journey of a startup is challenging, right? And people, through the course of the journey, figure out that, well, one, this is maybe not for me. Second, maybe I have better opportunities. Or third, or whatever, it's not working out between the co-founders. Whatever the reason is, but this happens often. The problem, however, is that if you do not have a mechanism which has been pre-agreed to take care of the equity which has already been allotted to the co-founders, what do you do about it? So you have a situation where a co-founder has exited or is not spending as much time or is not willing to spend as much time or is promised you that he'll quit his job, his daytime job, to join you once the business starts taking shape, but he does not because he chickens out. What happens to the equity? And this is a disastrous situation for any startup to find itself in, because if you have a 50, 30, 20% equity stake, giving to a founder who is not contributing to the business, I think the business is dead. One, because then there is not enough incentive for the other co-founders. There isn't enough equity then to dilute to future investors. And third, even investors don't want to touch a company like that, because then investors don't want to dilute their co-founders beyond a point. And where is the room for it if one of the co-founders is sitting on 50% and not contributing to the business? Are we clear so far? So one thing that we do, and this is in the whole host of things that we provide in the co-founders agreement, I think the most important thing that you should all be very careful about is this part of it. One way to structure this or to kind of resolve these kind of issues is what we do is, it's called as vesting of stock. Right, so basically vesting of stock is supposedly, going back to the situation I was talking about, two co-founders holding 50% stock each. What we do is, we lock in that equity which is given to the two co-founders. What that means is, you have 50% equity, but you cannot sell or transfer that equity. With every passing month or 2 months or quarter, we will start releasing you a small portion of that equity, which can be transferred. So let me play it out. Supposingly, we say that you have a 3-year vesting period. We say that you will get your 50% in entirety only if you stick around with the company for 3 years, or 4 years, or 2 years, whichever way you want to structure it, right? The three years means 36 months. We say that we will, every month, we will release you 1/36th portion of equity, provided you are working that additional month, right? So if one of you decides to quit after 1 year, you are entitled only to the equity which has been released, which you have earned in the first year, which is 12/36. Clear, everybody? Supposingly, before the 12th month, this employee is thrown out of the company for reasons of fraud. So we can structure those kind of situations. If you are thrown out for fraud, we say that, well, you're not entitled to anything at all. 36th portion of your equity which you have earned will not be given to you, or it will be given to you, but maybe you'll not get all of it. You'll get half of it. You know, so these are the kind of structuring that we do based on, I mean, after evaluating the circumstance, but after interviewing the founders, stuff like that. So this is how we vest equity over a period of time. Also, what we do is typically there's something called as a cliff period, which is the equity will not start releasing to you in the very first year itself, because the philosophy is like you should have, if you're a co-founder, you should commit at least 1 year or a half a year, start to demand something back from it. If you've not even spent 6 months or 12 months in the company, then you've added no value really. So we don't want to give you equity only for 2 months or 3 months of your working in the company. So if supposingly one of the co-founders die, or you have a disability, or you cannot attend to the business anymore, we provide for some compassionate grounds as well, wherein the equity can be passed on to your your heirs, or we can provide that you do not lose out all your equity. You still earn the equity, supposing there's a disability, right? Because of which you can genuinely not attend to the business now. So we will be a little more compassionate in the way the equity will be distributed to you. So we always structure these things. So typical vesting period that has become a standard in the investment circles is about 3 or 4 years, and with a 1 year cliff. So 1 year, the equity does not vest. After that, it begins to vest for the next 2 or 3 years. The equity which is released to you, you can sell it. Typically what happens is that sophisticated investors or institutional investors, maybe not angels so much if they don't understand this, but sophisticated investors will typically start or restart the vesting all over again. Because it's very important from an investor's point of view that your equity is not given to you upfront. Again, the same concern. What if one of you leaves, right? The investor is in a situation in a company where one of the co-founders is not contributing, but sitting on a major stakeholding. So typically the investors will anyway bring it in. And that's why this becomes very important, even at a pre-investment stage. Because if at a pre-investment stage only your co-founder leaves and you didn't have a vesting, I think investors are less likely or are going to find you less appealing to invest into. However, just one more thing. If the investor is coming in at a much later stage, say after 2 years, or 1.5 years, you can always negotiate saying that, listen, I'm not going to restart the vesting. I have already, stuck around with the company for a year and a half. We are going to continue as it was. So it can be negotiated. Some investors say that beyond the vesting also, your lock-in will continue for 2 years. So you can't sell the shares even after 2 years. Now, my typical argument to these investors is, then what is the point in having a vesting, right? And we try and negotiate that. But there's a reason why. See, what happens is, the reason for, very honestly, no investor is actually expecting or even wants that you exit, you sell your released shares in the first 2, 3, 4 years, or before the investor himself has exited. They want the startup, the promoter, to be locked into the company until they have exited. So their reason for vesting stock to you is not so that, okay, you have earned 2%, you should be able to transfer that 2%. They won't even want that. They will still lock you in. The reason why you have vesting in that case is for the reasons when a promoter quits or terminates, is fired. How do you calculate what is the equity to be given to the promoter when you have quit the company? So the way we do it is, supposingly, as I described, if 1 year down, you were fired from the company for reasons of fraud or otherwise, we have a mechanism to calculate the equity that should actually be given to you, or that should be clawed back by the company. Does that make sense? So it is for that, it is that formula really. I mean, other than practically speaking, you're still locked in and you still can't really sell your shares. But there are a lot of other provisions you need to really think about. Most important is non-compete. What if the housing co-founder leaves? And obviously the next best thing he can do is to start a competing business in property rental, right? For example, so non-competes are very important. And structuring of non-competes is also something which is very important. What is it that you can do or cannot do? And for how long can you not do it? Under the law, there are peculiarities which say that supposingly if I'm fired as an employee or as a co-founder, you would ideally want to say that, well, you will never start another housing rental company in your life. The law says you cannot have that provision because under the law, it's a public policy thing that you don't, I mean, ultimately all this guy knows is housing rental. He doesn't understand any other industry. How can you stop him from doing the one thing that he understands? What we typically do is we try and provide a reasonable time period for which you can have the non-compete. So maybe 2 years, 1 year. There are some other nuances to it. The reason I'm telling you this is that this non-compete needs to be thought through a little bit from a legal perspective. Other provisions that are important are confidentiality. What happens once you quit to the confidential information? You need to erase that information. You need to give back the documents. You cannot solicit employees from the company. You cannot poach employees from the company. You cannot poach customers from the company. You cannot even poach vendors, for example. In certain cases, we can also provide for that. In the co-founders. Another important one is IP, which is very, very relevant. Now imagine, a lot of times what I see happening is one of the co-founders develops a product and then another co-founder comes and joins him. Now this IP was developed by one person. It is possibly even registered in one person's name. To make sure that this IP is assigned to the business is absolutely important. Otherwise, no investor is going to touch you. Second is, what happens to the IP which is developed post you coming together? So in due course, as one person is developing IP, the other person is the business development head, right? He's not developing IP, but the IP should be assigned to the company. That's critical. So co-founders agreements provide for a number of these kind of things. The other thing is, what if you don't have the money yet, right? Or you're not sure whether this business is going to even take off. My suggestion to you is this. Even if you don't want to go to a lawyer just yet, definitely document co-founder arrangements. Even if you document that on an email and exchange that email between your co-founders, can actually go a very long way, okay? One is, there is value. See, to enter into a contract, you don't necessarily need a contract which is written down on paper and which is signed by you. Even an email can actually constitute a contract if both the parties agree to the terms. If both parties see it as a binding document, that is also a contract. So by all means, if you're not going to a lawyer, understand what I have to say here, read up a little more on the internet and draft out your own thing in simple language. A contract can also be very simple to read. It doesn't have to be legalistic and complex. So do a simple email exchange, right? The other thing, we don't only prepare for a situation which goes to the court. That is really not in my mind when I'm advising you as a lawyer. Most often than not, even if you have a document and you have a situation, you will probably not go to the court, and I'll advise you not to go to the court because many times it doesn't make sense, right? But the advantage of having a document is that when you have a dispute or an ambiguity, it is a great guiding, it's a compass, right? It is something which co-founders go back to and say, well, you know what? Yes, we had agreed on this. This is not an issue I can make with or fuss about. Many a times you may have agreed to something orally, but there will be an ambiguity until and unless you have actually sat down together and written it down. So to avoid those situations, it is always better. It really brings out a lot of clarity in the co-founder relationship also. So I think even between your question, friends or family, and family is the most dangerous because people often don't talk about things. Because one, it is a hard conversation to have. And second, it's a hard conversation. You can't openly talk about a lot of things, right? The trouble with that is you may go 6 months down doing your business, assuming that it was an unsaid understanding that we are going to, for example, West, right? But it doesn't work out like that. If you've not discussed it properly, it is always going to lead to a dispute. And within a family or friends scenario, it can always get murkier. If you can do this in an email, great. I mean, do that to start with. Typically, we provide very comprehensive, I mean, depending on the stage of the relationship, depending on the criticality, we can do very simple agreements, 5, 10 pages, or we can do very comprehensive 60, 70 page agreements also. So it depends on how much, the co-founders are, how much is at stake really, right? One ground rule: your memorandum and articles of association always supersede any other agreement that you will have. Your articles can provide for co-founder terms, but somebody needs to do the thinking, right? That how do you draft the articles? If you have not thought about it, if it's a model AOA which everybody else uses, it's not going to work because it doesn't have these kind of provisions. But if we want to structure the co-founder relationship, we can structure it in the articles also. I will recommend having a separate co-founders agreement for the reason that, see, understand, an article is not an agreement between the two co-founders. So if one co-founder needs to sue the other co-founder, he needs an agreement between him. What we do is we draft the agreement, and then we also replicate the terms in the articles so that you're covered from all sides. But of course, if you're at a stage where you are too early, you don't want to spend too much money in drafting both, or don't have the time to do that, even a simple email, right, where you document these things can really go a long way in maintaining some sanity in the co-founder relationship.